Hello, everyone. Welcome. My name is Maître Julie Dilly, and I'm a member of the Bar of Montreal and of the Aims for Justice Committee. To begin, I would like to thank Option Consommateurs, an independent nonprofit organization whose mission is to help consumers and defend their rights, as well as the Montreal libraries, particularly the Benny Library, which collaborated in organizing and promoting this conference. Please also note that you can find the conference program throughout the year on the website visedroit.com. Kindly note that there will be a Q&A session midway through the conference as well as at the end. Throughout the conference, you are invited to submit your questions in the Q&A section located at the bottom of your screen, and Maître Sarah-Ève Levac will be pleased to answer them. Without further ado, I am pleased to introduce our speaker for today. Maître Sarah-Ève Levac is a lawyer and analyst at Option Consommateurs, a nonprofit organization whose mission is to assist consumers and defend their rights. At Option Consommateurs, she focuses in particular on competition law and privacy protection. She contributes to the organization's advocacy efforts on these issues before various bodies. Maître Levac holds a Bachelor of Laws as well as a bachelor's degree in International Relations and International Law from the Université du Québec à Montréal. She also completed a master's degree in Public International Law at Leiden University in the Netherlands. Welcome, Maître Levac.
Thank you,
I'm now
Medili.
I now invite you to begin with your presentation.
Thank you, Medili. Welcome, everyone. Welcome to the conference on on one informed consumer as a power of 10. Um, we are going to talk about consumer protection today. I am launching. Is everybody capable of seeing my PowerPoint right now? Okay, so when informed consumer has the power of 10, we'll talk about consumer protection and your rights as consumers in Quebec. We're going to go over some different subjects. And to start, I'm going to present us. So, Maidili presented Option Consommateur. So, we are a non-profit organization that was created in 1983. And over the years, we have developed expertise on different areas to defend consumers and protect their rights. So we look at questions such as debt, financial services, privacy, access to justice, and business practices. If ever you need our services are free and they're available if you go on our website or if you call us. So it's dash consommateur with an S, so plural.org. We have a different kind of services that are free to use. We have first a legal service. So if you want to have information about your rights and recourses in cases of a problem with a merchant, you can call us or contact us, and a lawyer will get back to you with an answer to discuss your rights in your particular situation. We have a budget consulting service as well. So if you have difficulty balancing your budget, you want to talk to one of our consultants, you can schedule an appointment to discuss your budget. We have a microcredit program called Prêt du Quartier, or neighborhood loan in English. It's a microcredit that is offered for purchases that are not recurrent. So if ever you have a problem with your fridge that broke down, you need a new one or a pair of glasses, you can call us for a small loan. You are eligible if you're on the territory of our organization. So that would be at the north, Van Horn, Rosemont. On the south, it's the river. On the east, it's Pineuf. And on the west, it's Guy and Côte-des-Neiges. For the neighborhood loan, if you are not residing on our territory, you can go on the website toutbiencalculer.ca to see what organization is on your territory. But you can still contact us for legal service, for our legal service or consulting service if you're not residing on our territory. It's really for the microcredit program that there is a condition to reside on our territory. And we also have information and awareness activities such as the one we're doing today to inform you of your rights and your recourses if ever you have problems with a merchant. So today we'll go over your rights as consumers. It's not we won't talk about the articles in the law. We'll go over general principles and what applies to you um, in situations with a merchant. So we'll talk first about the Consumer Protection Act and the protections therein in Quebec. We'll go over certain general rules. So we'll all start with the same concepts and principles. And then we'll talk about the refund policy, the price accuracy policy, a very useful tool when you go to the grocery store, for example, the warranties and online contracts. Afterwards, we'll talk about telecoms, so your contracts with your telecom provider, internet service provider, cell phone provider, TV provider, for example. And if we have time, we'll talk over options in case of disagreements with the merchant, but we will probably get over a lot of your options throughout the conference and with the questions. So if we have the time, we can look at a bit more at your recourses. So to start, the Consumer Protection Act, it's a provincial law. So this covers you as a consumer residing in Quebec. We'll go over, like I said, the general rules, warranties, policies, and online contracts. So just to start to all have the same information to start with about without going further on the Consumer Protection Act. So we'll talk about contracts that are formed between a consumer and a merchant. As a general rule, a contract is simply an exchange of consents between two persons. So it can be written or just verbal. There's no particular form provided for by the law, but there are, of course, exceptions in the Consumer Protection Act. There are many contracts that need to be written down to protect you as a consumer because we consider that the consumer is the most vulnerable person in the relationship with a merchant. So to provide better protections, we have to have some written contracts provided for by the law. And another rule about contracts is once you form a contract, once you sign on to a contract, it is binding and it creates some obligations. When we talk about consumer protection, normally the contracts is for the obligations that are created is for the merchant to deliver the good or the service you paid for, and your obligation as a consumer is to pay for the good or the service. That being said, this is the general rules of contracts, but there are some contracts that have specific rules and specific forms. For example, online contracts that we'll talk about a bit later on. Um, so now that we've mentioned contracts, the Consumer Protection Act, when does it apply? It apply in situations where you enter into contract with a merchant being a person that is running a business, to make a profit. So the rules we talk about today will apply to situations where you go to the library, where you go to the grocery store, where you go to the dépanneur or the convenience store. So every time you buy from a merchant, you have some protections under the Consumer Protection Act in Quebec. It applies to every contract you form to buy a good or a service. So if you go buy a pair of shoes or if you go to a tanning salon, the rules will apply. There are rules for those kinds of contracts. It also applies if I buy something or I rent something. So if I buy a car or I rent a car, I have protections. I have protections under the Consumer Act, and of course, there are some exclusions. The law really likes some exceptions, and in the case of the Consumer Protection Act, it's important to know that there are some types of contracts that will be excluded with certain persons. So if I go see a professional under the code of the profession, so a doctor, a psychologist, a dentist, a veterinarian, these rules will not apply to the professionals. And also, these rules won't apply if I am in front of my landlord for my apartment, for example. So in these cases, it's not the same rules that will apply. But if I go buy from a merchant, the grocery store, the library, the convenience store, then I have the protections afforded to me by the Consumer Protection Act. The Consumer Protection Act has a number of rules and specific rules for certain types of contracts, but a general rule in the law is that it's setting the rules for the practices of businesses. And sometimes some practices are specifically prohibited in the law. So merchants cannot give you false or misleading representations in the publicity you see or in any representation from a seller at the store. They cannot tell you things that are untrue about the goods and services they are selling, and they cannot omit an important fact as well when they're presenting a product to you. An important fact being something that would change your choice to buy something and the price you're willing to pay. So, for example, if I go buy a used car that has had an accident, this is an important fact that is supposed to be disclosed to me because it would affect my choice to buy or not this car and the price I would pay it at. So, the price I'm willing to pay for it if I know it's been in an accident compared to if I am not advised of this information. So there are rules about the representations merchants can do to consumers and what form they can take. And also a good thing to note is that the Consumer Protection Act is a law of public order. This is a legal term that basically means, if we vulgarize it, that the if you have a contract with a merchant, the contract cannot say the opposite of what the law says. You cannot sign away your rights that are provided for in the Consumer Protection Act. I give two examples here in the slide. So sometimes merchants will make you sign a waiver when you receive, for example, the delivery of appliances. It will say, I have inspected my new washing machine and everything is in order. And they will ask you to sign it, saying sometimes, I waive my right to the legal warranty. The legal warranty, we'll talk about it later. It's provided for in the law, and it's a right that you cannot sign away uh, by signing this type of waiver. So even if the contract says that you waived your right to a legal warranty, you sign something that says you waive your right to a legal warranty. This will not have any effect because the Consumer Protection Act is a law of public order, and you cannot sign away your rights. Same thing with a lot of terms and conditions online. We'll have a clause that looks like the second one that says, I agree that any dispute must be settled exclusively in the U.S. District Court for the Northern District of California. Uh, we see those a lot in contracts online. And the Consumer Protection Act says that uh, a merchant cannot restrict your rights to use your recourses here in Quebec, so they cannot tell you that you cannot go to small claims court, for example, that you need to go to mediation in Northern Carolina, sorry, or California. You still have your rights and recourses here in Quebec, even if there is a contract that says that the dispute settlement system is in California, for example. So having seen the general principles and the basis of the Consumer Protection Act, we can talk about specific subjects from now on in consumer protection. So, first, the refund policy. So, a lot of times, consumers call us, and they tell us that they bought something and the merchant does not want to take it back, even though it hasn't been 30 days since they bought it. This is a common myth because merchants are not required to implement a refund policy. Remember, I told you contracts are binding and they create obligations. So the general rule is that once I form a contract with a merchant, it is not a guarantee that I will be able to cancel my order and be reimbursed if I change my mind. Okay, there are exceptions to this. If the good is broken and doesn't work, we'll talk about warranties afterwards. But if I go buy a pair of shoes and then I get home, I don't like them anymore. I regret my purchase. It's not a guarantee that the merchant will take it back and refund me because a refund policy is a choice that the merchant decides to offer to consumers. And as it is a voluntary contract, a voluntary policy, there can be some rules in the refund policy. So they can say that you have 30 days to bring back a good. They can also say, taking back my shoes, that if I worn them outside, then the refund policy will not be applied. So that I can't get a refund if I wear my shoes outside. So there can be some rules. So it's a good idea to check what the refund policy says if the merchant has one before buying something in case you change your mind. And like I said, if it's broken or if it's not what you bought, if you receive something that is not what you ordered, there are these situations are different and you can have recourses. But if you change your mind, in general, you cannot cancel your contract and be sure that the merchant will take it back. So if the merchant does have a refund policy, they have to respect it. So they cannot apply it nilly and change the rules as they please. They have to follow the refund policy, and it also has to be available to you to check before you make a purchase. So it might be at the store next to the cash registers. It might be on their website, for example, but you need to be able to know what exactly the rules are of the refund policy if the merchant has one. Talking about policy, now moving on to something else, the price accuracy policy. I imagine you've all seen this image in stores, the one that says politique d'exactitude des prix. So that's the price accuracy policy. It's available in French on the Office for Consumer Protection website, but it basically says that if you go to a store that uses a scanner to scan the price of the object you're buying. So I go to the grocery store and the price of my box of cookies is on the label on the shelf and not on the product itself. Usually the price is on the label next to my box of cookies. And I go to the cash register, and then when it's wrong at the cash, the price is different and it's higher than what was written on the label. I can have a compensation for that. So if I buy something, the box of cookie on the shelf, it says it's 3.99, and then I go to the cash register and it rings up at 5.99. This is an error that is unfavorable to me. I can ask for the price accuracy policy to be applied. So I can ask for the box of cookies for free because it's $15 or less. So every item, $15 or less, if there's a mistake that's unfavorable, I can ask for it free of charge. And if the item is more than $15, so I grab a bag of coffee, for example, at the grocery store, it's supposed to be 15.99, and at the cash register, it's 17.99. Again, it's an area that's unfavorable to me as a consumer. I can ask for the price accuracy policy to be applied. So in that case, there will be the correction of the price. So instead of 17.99, it becomes 15.99, and I get a $15 rebate for the object that's more than $15. So I get sorry, I get the good for 99 cents in this case. Yeah. So this is a very useful tool to have when you go to the grocery store if there are any mistakes. One thing to note is that if I buy several of the same items, so my box of cookies that I'm supposed to get for free because of a mistake, then I do not I do not get three box of cookies for free. I only get the first one free, but the other ones will be corrected. So instead of the 5.99, I will pay 3.99. And also there are again some exclusions to certain types of goods. So at the grocery store, if I buy some fruits that are in bulk, that are not packaged already, then the price accuracy policy will not apply in those situations. Some types of goods are also excluded, like beer, wine, and spirits, because the price is set by regulations for these types of goods. So the price accuracy cannot be applied so that the price is lower than what is set by regulation. Same thing for milk and tobacco, and then certain types of medication. So the price accuracy policy applies if there are labels on the shelf that indicate the price, and there's a mistake when I scan the barcode for the product at the cash register. If the price of the item is on the item itself, so there's a price tag stuck on the item instead of the price being on a shelf, and there's a mistake at the cash register again, in those cases, it won't be the price accuracy policy that applies, but you will be entitled to ask for the product to be sold to you at the lowest of the two prices. So those are different tools you can use if ever there are mistakes at the cash register when you go buy something. So it's good for the grocery store, but it's also applies at the pharmacy. Um, Not when I go to the pharmacist, because that's a professional under the code of profession. But if I go at the pharmacy to buy some things, like a pack of gum, for example, then the price accuracy will apply because the price is on the label on the shelf, and then they ring the object at the cash register. Following the policies, we'll talk about the warranties. Warranties are a good tool to have as well. We'll talk about three different types of warranties. Sometimes there might be confusions between the different types of warranties, so we'll try to untangled the three types we will cover today. So we'll talk first about the legal warranty. Legal warranty, it says it in the name, it's in the law. It's provided for by the Consumer Protection Act. And then we have other types of warranties as well that you probably have heard of. The merchant or the manufacturer's warranty, that's a contract, and the extended warranty, it's also a contract. So we'll see the differences between the three types of warranties. The first, the legal warranty. So that's a warranty that's in the Consumer Protection Act. It covers all goods that we buy or rent from a merchant in Quebec. And what does it say? Well, it provides a protection for every object to be used regularly as regularly intended, sorry, for a reasonable period of time. So if I buy a watch or a fridge or an oven, it's all covered by a legal warranty. If I rent a car as well, it's covered by the legal warranty, and this warranty says that the good has to be useful. It has to have a reasonable lifespan. What's the reasonable lifespan? Well, that's a good question because right now there is no set time for the duration of a good we buy or rent. But we always say that the legal warranty is a warranty of common sense. So the question to ask yourself is it normal that, my fridge breaks down after a year? So if I buy a fridge and it breaks down after a year, uh, usually you would think that it's not normal. Nobody expects to buy a fridge and to need to replace it a year later. So that's already a good sense of the application of the legal warranty. When there are flags that are raised when I think that, oh, I think I bought something, but it hasn't been that long. I think it's not normal that it's not working anymore. That can be a sign that there's the legal warranty that still applies. And the duration will vary according to the quality or the price of the object. So if I buy a watch at the dollar store and it breaks down after 3 months, I don't know, might not be still under the legal warranty. But if I buy a watch that's a couple of thousands of dollars, then after 3 months, that wouldn't be normal that my watch breaks down. I would think that I wouldn't have to change my watch, my expensive watch, after a couple of months. So that's an idea of the legal warranty. The legal warranty will also protect you from receiving an item that is conformed that is in conformity with what you bought. So if you go to a store to sign a contract, so let's say you're buying a chair uh, covered in leather from the store, and then what you receive is a blue chair covered in corduroy, sorry, then it doesn't match the description of the objects according to the contract. So then you also have a recourse to have it corrected so you can have what you actually ordered. So this is part of the legal warranty, the use to durability and the conformity. And when it comes to the use and durability of the goods, so it breaks down prematurely, you have recourses against the merchant or the manufacturer if the good breaks down. So if my fridge breaks down after a year, I can ask either the merchant or the manufacturer, or I can even contact both of them to have it either reimbursed, repaired, or replaced at my choice. Of course, you can't have a double reimbursement, but you can talk to both of them to have the problem solved. If there's an error in the delivery, for example, my chair, my leather chair, then it's usually you would use your recourse against the merchant who made a mistake in delivering you the good. But if my good breaks down, then I have recourses against the merchant or the manufacturer. Even though sometimes we hear consumers calling us saying that the is saying that there's nothing they can do and you need to call the manufacturer, actually you can still ask the merchant to have the situation resolved. Sometimes merchants will be in Quebec and manufacturers are abroad, so it can be easier to use your rights and recourses with the merchant in Quebec, for example, even though the merchant might tell you that you have to talk to the manufacturer instead. So that's the legal warranty. The other type of warranty that we see that we will talk about is the manufacturer's warranty or the merchant's warranty. That's a contract. So it's not in the Consumer Protection Act. It's a contract where the merchant is offering you a warranty for a certain amount of time. Usually, the manufacturer's warranty is for a year. It's a warranty that we often see when we buy something. You know, there's a little card inside the box that says manufacturer's warranty for 1 year. And they say you need to sign the paper and send it to the company to have the warranty to activate it. The law in Quebec says that you do not have to send this card to benefit from the manufacturer's warranty. So once again, we talked about the law of public order, even though the written contract says the other thing, says something different than from the law says. The law says that you can still use the manufacturer's warranty if you haven't sent back the little card with the 1 year warranty. Since it's not mandatory, it's a choice by the manufacturer. It can have some conditions. So, come certain parts and certain types of repairs can be excluded in the manufacturer's warranty. It is free. Usually, the manufacturer's warranty will be given to you when you buy something for a year, and it normally applies concurrently with the legal warranty. So a good can be protected by different types of warranties at the same time. So in this case, the manufacturer's warranty and the legal warranty. So the manufacturer's warranty is a contract. Another type of warranty that is a contract is the extended warranty. The extended warranty is one that we usually have to purchase. So you will go to the store, you will buy an appliance, and they will offer you to purchase an extended warranty. An extended warranty extends the manufacturer's warranty. So if I have a year, usually they will add 2 or 3 years to have a 3 year or 4 year extended warranty on what I bought. And it's usually pretty expensive. The extended warranty will often be 25 to 30% of the price of the good itself. So it's very expensive. And there can also be some conditions that apply, like with the manufacturer's warranty. So there can be some parts that are excluded. There can be some types of repairs that are excluded. They can also provide that there are some fees to pay. For example, if the repair person needs to come to your home, they might say that you have to pay for the kilometers the repair person will have to drive to get to your place. So these are the types of conditions that you can have in the extended warranty. Another thing to note is that before selling you the extended warranty, the merchant is supposed to tell you about the legal warranty before selling it to you. So they have to verbally tell you about the legal warranty and also give you a little a written notice of the legal warranty before they sell you the extended warranty. And this warranty can apply concurrently with the legal warranty and the manufacturer's warranty. So we can have three types of warranties that apply at the same time. Usually, the legal warranty will be much longer than the manufacturer's warranty and even the extended warranty. I spoke about my fridge again. So my fridge will come with a 1 year manufacturer's warranty. I can pay a certain amount of money to have it extended to, for example, 3 years. But in the case of a fridge, the court has already estimated that the legal warranty can be between 10 and 15 years, depending on the types of fridge. So the legal warranty will normally, in general, be longer than the other types of warranties. And this type of warranty is in the law and doesn't provide for exclusions or fees that you have to pay as a consumer. So it is a good umbrella protection on every good you buy or you rent in Quebec. There have been some modifications to the law recently, and other warranties are being put in place. One warranty that is going to enter into force in October of 2026, so of this year, is the legal warranty of good working order. It will apply on certain types of items only. So big appliances and electronic devices will have a minimum amount of time where they have to work properly. So it will add another warranty on top of the warranties we have spoken about because it will apply concurrently to the other types of warranties, but it will set a minimum amount of time a fridge, a washing machine, a television set, or a video game console needs to work properly. And if these objects break down before the end of the good warranty, the legal warranty of good working order, then you'll have recourses that are made a bit easier for you to have the good replaced or repaired against the manufacturer or the merchant. Okay. So, I have spoken about the legal warranties being a warranty of common sense, let's say. If you want some help to have an idea of what the length of the legal warranty is for different appliances or goods, you can go on the Office de la Protection du Consommateur's website, so the Consumer Protection Agency in Quebec. And on their website, they have some decisions by the court that have been rendered for different types of goods. There is a section with different types of subsections. So you can see for a car, for a washing machine, for a dryer, for example, you click on it and you'll have a compilation of decisions that have already been rendered by the court. And it will tell you, for example, if you have the washing machine that broke down after 3 years, if the consumer gained their claim, if they were awarded an amount of money for the good breaking down. So you will have an idea of the length of the legal warranty. This tool is in French only on the Office for Consumer Protection's website, but there are ways on your browser to translate it in English if ever you cannot read it in French. So we can have a first question period if there are some questions in the chat. I don't know, Medzili, if there were some questions so far.
I don't see any questions, but I might have some. You mentioned l'Office de la protection du consommateur, and
Mhm.
your organization's name is Option Consommateur. What's the difference between the two?
Yeah, that's a question uh, we receive frequently. So the Office for Consumer Protection, l'Office de la protection du consommateur, It's an independent governmental agency that supervises the application of the Consumer Protection Act, amongst other acts as well. So that's the organization that can do inquiries and maybe ask for penalties from merchants that will uh, not respect their obligations under the Consumer Protection Act. And Option Consommateur is a non-profit organization, so we are not affiliated to a government. We're not a governmental agency, and we cannot start inquiries and um, go inspect, for example, the practices of the merchants, but we do help consumers when they call us to defend their rights, to know their recourses, and we can also make representations to the government officials to have some changes to the law to protect consumers, for example.
I do have other questions here. Um, I have a question here. If the merchant does not respect the legal warranty, I imagine the consumer will have to go to small claims court. Do the courts give all the consumer his costs?
Ah, it's a good question. So, if we always say that it's a good idea to try to solve the issue with the merchant. So, before going to small claims court, you would need to notify the merchant or the manufacturer if there's a problem to try to solve it directly with them. If that doesn't work, there is at the Office for Consumer Protection a mediation platform that is free and online. It's called Parle Consommation. And some merchants participate in this program. So if the merchant participates in this program, you can have a free mediation to try to solve the issue directly with the merchant or manufacturer before going to court. And then if that doesn't work, you can't arrive at a settlement. You have to send a letter of formal notice. And if that doesn't work again, then small claims court. So if you go to small claims court, you can indeed ask for the costs. So you have a fee to open the case at the court, depending on how much you're claiming. It can vary from 118 to 200 and something. I don't have it off the top of my head, depending on the amount you're claiming. And you can ask for the merchant to have to pay these legal costs, these fees, sorry, if you win your case. Another thing to note is that at small claims court, we are not represented by a lawyer, so there are no costs to pay for representation because people are not represented. Judges are used to having people represent themselves because there's no lawyer for. So in terms of costs, normally at the small claims court, we're only talking about the small fee to open the case.
Thank you for that. Another question. What is the interest rate for the neighborhood loans?
There's no interest. In our case, you have to see if you don't reside on our territory, you have to see what your organization offers, but there's no interest.
Perfect. Maybe one last question that I might have.
Mhm.
You talked about the legal warranties. What happens if the merchant goes bankrupt?
Yeah, that's a good question. If the merchant goes bankrupt, it can indeed be difficult for you to use your recourses. In the case of a legal warranty, you can always ask the manufacturer if the good breaks down prematurely. But if there is a bankruptcy, then in that case, you have to talk to the syndic de faillite, I don't know the translation for I don't know, Medili, if you know the translation for syndic de faillite, but the insolvency, the institution that looks over the bankruptcy, you can contact them to try to get part of your money back, but it's more difficult. So if you have a problem with the legal warranty and the merchant goes bankrupt, I would say you could look at the manufacturer instead, because the law says that you have recourses against both in those cases.
Perfect. It's the bankruptcy trustee that you would contact.
Bankruptcy chips.
Yes.
Thank you.
Perfect. I don't have any further questions. Would you like to continue?
Yes.
Perfect.
Okay. So now we'll go over online contracts. So online contracts are basically when we buy something online. So since 2020, we've all moved more with an online presence and use of of transactions online. So it went up for the past 6 years. And now we buy a lot of things from an online merchant. But there are some things to verify before completing a purchase like this, or good practices to have in case of problems after buying something online. So, good tips first before buying from a merchant online is to verify the merchant's information. So, we can see some ads on social media, for example, for merchants. It's a good thing if you see an ad for a merchant you've never heard of to make some verification beforehand. We've had consumers call us where they bought something after seeing an ad and they never received what they purchased. So it can be a good idea to check the information about the merchant. So first, you can go on their website, try to find if they have any contact information in case there's a problem. If there's an email address, a telephone number, an address itself, a physical address, so that you can know if there are contact information in case there is a problem with this merchant and you don't receive, for example, your package. Also, check if they have an exchange policy or a refund policy. So you know that if you change your mind, if there's something you're not satisfied with, you can see what their policy is to return what you bought. You can search also the merchant's history on the Office de la Protection du Consommateur. So I'll show you afterwards how to do that. But you can go on the Office for Consumer Protection's website and get a number of information about a merchant. It's a good thing we see to compare prices. Sometimes we buy quickly without thinking too much because we see an ad with a good promotion online, but you can take the time to verify if the promotion is a good one and if you're paying something that is comparable to other objects on the market, similar goods on the market. Be mindful of countdowns, for example, about a promotion. Those can be tactics to make you buy quickly without thinking too much. So just good practices to avoid buying something and regretting it. And also be mindful of freebies and trial periods. So at time of recording, there is no obligation to inform you at the time of the end of the trial period, so sending you a notice for it. There was a bill under study, so it might change in the future. But if you sign on to a trial period, for example, you want to try a streaming service and you want to try a trial period, sometimes it's the price is lower for the trial period or it's free for the trial period. You will sign up and they will ask for your credit card. So the first month is free, and at the end of the month, you get charged for the price. They're allowed to do this, but it's a good practice to put the end of the trial date in your agenda or your calendar so that you do not forget to unsubscribe before the end of the trial period, and it gets surprised at the end of the month because you are charged on your credit card for the service afterwards. There is a law that was being studied to make it make an obligation that the merchant sends you a notice before the end of the trial period. Because so far merchants they're counting on you to forget to unsubscribe. But so for now, it's a good practice to write it down in your agenda, your calendar, to not forget to unsubscribe. So I will show you how to um, get information about a merchant on the Office for Consumers website. So when I land on the Office for Consumer Protection website, the Office de la Protection du Consommateur, That's on www.opc.gov.qc.ca. So Oscar Papa Charlie dot Golf Oscar Uniform Victor dot Quebec Charlie dot Charlie Alpha. Make sure you are in the section dedicated to consumers, and you will see there's possibility to get information about a merchant here. You can enter a merchant's name and get information on the merchant. There's also a section here to get information about a merchant. So if I go to search for a merchant, let's say I go for checking Canadian Tire, I have to, of course, acknowledge the terms of use, and I go on finding a merchant. So the results are in French on the website, but once I search for a merchant, I get results for the name I typed. So I will get all the names of all the merchants that match what I searched for. Here we were looking for Canadian Tire, so we have the result here. I can click on it. I will get information about the merchant. So I'll get the name of the company. I'll get all the other names they have associated. I'll get their address, which can be useful if I need to send a formal notice to the merchant in case of problems. I'll also get some information on surveillance. So if the Office for Consumer Protection has deemed that this merchant may have not respected their obligations under the law, I will find information here. I'll find information under litige, so that's conflicts basically. If the merchant is participating in a mediation platform, here we see that they do not, but this is a useful information to have because if ever you have a problem with a merchant, you could contact the Office for Consumer Protection to get possibly a mediation to try to solve the issue with the merchant itself. You'll also get the formal notices sent by consumers. So if ever you send a formal notice to a merchant, you can send a copy to the Office for Consumer Protection and they will enter it here for other consumers to see if other consumers have sent a formal notice to this merchant. And I'll also get some information on communiqué presse, so press releases from the Office from the Protection du Consommateur, the Office for Consumer Protection, that have been sent to this particular merchant. So this is a useful tool to get some information about a merchant on the Office de Protection du Consommateur's website. Okay, so these are tips for before we buy, and then during the transaction process, there are also good practices to protect yourself in case of problems. So if you want to buy something online, it's a good idea to check the description of the item before completing the order. The law provides that the merchant has to give you a chance to review your order before you complete it. So check the description of the item. I'm talking particularly about sizes. We've had situations where they were trying to buy a lamp, like a table lamp, not a table lamp, a big lamp for the home. But then they received a tiny table lamp. So check the description of the item. Review your order for the price. Does the price match from what was on the website, or is it suddenly more expensive? Confirm your address that you wrote down the right address for the delivery. Check your cart if everything is in order, and then you should pay with your credit card, so you can get an additional protection with the possibility to ask for a chargeback if ever there's an issue with your order. We'll talk about chargeback afterwards, but pay with your credit card because if you pay with another uh, another payment system, for example, or with a debit card, you won't get the same protection to be able to ask for a chargeback if there's an issue. Also, verify the delivery date. Usually, when we order something, there is an estimated delivery date that is given to us. You can write it down in your calendar as well. So if ever you haven't received the package by the delivery date, then there are some actions you should take to rectify the situation. After you've completed the order, you checked your cart, your order, everything was fine. You completed the order. Make sure to have a copy of your contract. This is a type of contract that needs to be written. I was speaking about that earlier. Usually, what happens is that we will receive by email a confirmation of our purchase with the contract. So, what we bought, what price, what's the delivery date, what's our address. So keep that in your inbox in your as a in your email so you can have it later if there's an issue. Write down the delivery date, as I said, put it in your calendar, in your agenda, and make a note of payment terms if this applies. We are seeing more and more merchants online offering buy now, pay later options. So you will buy something and pay it in several installments. So let's say I pay $5 for 6 weeks to complete my purchase. Make a note of that because if you use this a lot, then it starts to add up. And then for budgetary reasons, to know exactly how much you owe at the end of the month and what you will have to pay, it's a good idea to note your payment terms and the installments that you are for the payments that are coming up on what you bought online if you use pay now, buy now, pay later options. So the contract needs to be written. You don't need to know all of this information by heart, but the thing that is important is to know that the delivery date is supposed to be in the contract. That's very useful to have. The description, if ever there is an issue with what you receive that is not in conformity with your contract, you're supposed to have the description and also the price of what you bought and in what currency it is supposed to be. So sometimes people bought something online, and at the end of the month, they noticed that it was actually charged in US dollars and not Canadian dollars. In those cases, you can have recourses because the currency is supposed to be indicated, and you're not supposed to have a surprise at the end of the month because it was actually more expensive than you thought because the currency applied was not Canadian dollars. So the law provides for some protections if there are some problems with your online purchases. And there are some situations that are provided for by the law, and there are some deadlines to respect in the law as well, according to these types of situations. So the three most common types of things we see is first is the stolen package or the package that is never delivered. The merchant has the obligation to deliver what you bought. Okay, so even if your package is stolen or it was lost, you have recourses against the merchant to rectify the situation. Even if the package was delivered and you get pictures from the package in your porch and it got stolen, you still have recourses to against the merchant. Unless you specifically ask them to leave the package on your porch, even though you weren't there to open the door. In those cases, you might not have the possibility to have a refund in case the package is stolen. But in general, if they just leave it on your porch without you agreeing to it and it gets stolen or the package is lost, you have recourses. And in this case, after 30 days after the estimated delivery date or 30 days after you bought the good, if there are no estimated delivery date, then you can ask the merchant to cancel your contract and be reimbursed. We'll talk about how to do it right afterwards. So what's the technicalities? But so 30 days if you haven't received anything. If you receive something, but it's not what you ordered. So I bought a green pair of shoes, but I received a red pair of shoes. It's not what I ordered. It's not what was provided for in my contract. Then I have 7 days to cancel the contract once I receive the good that is not what I actually ordered. That doesn't match the description in my contract. And the other case is the email confirmation. So I'm supposed to get the contract, the written contract by email. If I don't receive it 30 days after I concluded the contract, then I can cancel the order as well because I didn't have the written confirmation of my contract. How do I do this practically if one of those situations arise? So let's say I bought something and 30 days after my delivery date, I never got my package. The thing I have to do is first to write to the merchant. So it can be by email, it can be a text message, it can be on their chat, on their social media, even. The importance is to get in touch with the merchant. And it's preferable to do it in writing so I can have proof that I've tried to contact the merchant if ever they don't reimburse me. So once I write to the merchant, I say, I never got my package. I want to cancel my order and be reimbursed. They have 15 days, sorry, to pay me back, to reimburse me, to respond to my message. And if they don't, that's when buying with a credit card becomes useful because in Quebec, we have the possibility to ask for a chargeback within the next 60 days. It's provided for by the law, so the chargeback is in the law. So if the merchant hasn't responded to me within the 15 days they were supposed to, then I have 60 days to turn back to my credit card issuer. Usually it's through my bank to ask for a chargeback. So the chargeback is exactly that. I can contact my credit card issuer when I have an online purchase that goes awry to cancel the transaction and get a refund. So if I receive something that is not what I ordered, when I don't receive something, when I realize that it was charged in US dollars instead of Canadian dollars, when I don't receive my contract, then I have recourses to ask for a chargeback if the merchant fails to reimburse me within the 15 days. How do I get the chargeback? Same thing as with the merchant. You have to write to your credit card issuer. You the law says that you have to do it in writing. Sometimes you can, if you call, they can agree to do it only by a phone call, but the law says that it should be in writing. You have to provide some information, such as your name, your credit card information, what you bought, at what price, so what merchant, what was the merchant's name, for example, and the steps you took with the merchant. So that's why it's important to use communications in writing with the merchant. So then, if you have to ask for a chargeback, you will have the proof that you tried to get the merchant to refund you first. So then you can ask for a chargeback from your credit card issuer if ever there is an issue with your online purchase. On our website, we have a downloadable, chargeback request form. So you can go on our websites. It's option-consommateur.org. In English, it's /en. You search for chargeback, you have the chargeback template, and you can download it so you can have an idea of the written request to your credit card issuer to ask for a chargeback. It's downloadable, so it's easy for you to use if ever you need to ask your credit card provider to get reimbursed. Okay. Sorry. So telecoms. We've seen the rules under the Consumer Protection Act. Now we'll see rules under the rules that apply to cell phones, televisions, and internet contracts. We all have those types of contracts, so it's a good thing to know your rights in these types of situations. Your rights will vary according to the types of contract you have, and we'll talk about how to cancel it if you want to change your provider, for example. We'll talk about a bit about roaming and data charges and what your recourse is if you have a disagreement with your telecom provider. So there are usually two types of contracts, of telecommunications contract. So we have fixed terms contract and we have open-ended contract. Fixed terms contract are usually 2 years, 2 years, 4 years. So essentially there is an end date to my contract. In these types of contracts, the key elements cannot be changed. For example, the price or the duration cannot be changed. So it's a contract you can consider if you want to have a certainty with your payments because the key elements cannot be changed in a fixed term contract. But for now, at time of recording, there can be a penalty for canceling this type of contract. We'll talk about it right after, but it will change in June 2026 because the CRTC issued a decision recently about penalties for early cancellation. So that's for fixed term contract. By opposition, the open-ended contract, sorry, is a contract that has no end date. So I sign a contract for my cell phone, but I will keep my provider for as long as I want to. There's no end date on my contract. This contract can be modified. So the price can change, of course. If I stay with the same provider for 5 years, there's a good chance that the prices will go up. So it's possible to change the key elements of the contract, but my provider is supposed to send me a notice 30 days beforehand to inform me of the change and give me a chance to cancel if I want to cancel and change my provider. But the price can change and conditions can change in the contract. The other side of the medal, so the mirror of that is that if I cancel early, there is no penalty except if they give me a device. We'll talk about that as well. But an open-ended contract can be changed and there is no penalty. A fixed-term contract cannot be changed, but there can be a penalty, which will change this summer, so very soon. And in all cases, if they gave me a device, we're talking about a cell phone, a router, a decoder, there can be some fees if I cancel early, but it's really because the device is not given. I'm paying it every month. I'm paying an installment every month. In those cases, if I cancel, I could be charged for the uh, rest of the money I need to pay on the device. So you can check your contract if a device is loaned or sold to know that if you cancel your contract, if you have a fee to pay for the rest of the item you were paying month by month. So canceling your telecoms contracts. You can always cancel your telecoms contracts. So your internet provider, your internet service provider, sorry, your television provider, your cell phone provider. If ever you're not happy with their services and you want to change, you can always cancel your contract, but there may be penalties applied. So if you cancel your contract and you contact them, of course, you have to pay for the services that you have already received. The services that were already provided to you, you need to pay for them. And there can be, in the cases of a fixed term contract, a penalty of 10% or maximum of $50 for the remaining months of the contract. But so in essence, it's a maximum of $50. This will change in June 2026 because the CRTC issued a decision. So if you want to cancel your cell phone contract, for example, you could wait until June because the cancellation fees are supposed to be waived or they're not supposed to be permitted afterwards, after June 2026. Open-ended contract, as I mentioned, have no penalties, except if they gave you a device at the beginning of the contract, whether it be fixed term or open-ended, you might have to pay for the price of the device if it was given to you at the beginning of the contract and you're supposed to pay it by monthly installment. To give you an example, if I have a contract with a telecom provider for my cell phone, and they gave me a cell phone at the beginning of my contract. My contract is 2 years. The cell phone is worth $1,200. Sorry. And I cancel into the contract. For example, I cancel 18 months into the contract, so I will pay every month $50 for the phone by equal installments. So if I cancel uh, before the end of my contract, I've already paid for 18 months. Then I will have $300 that will be left at the 18-month period if I want to cancel it. So that's a thing to keep in mind. If ever you were given a device, you can check your contract if it was loaned, as I said, or sold. So if there's a way you can just give back the device and not pay a penalty, but that's a thing to be mindful of if you want to cancel a contract that came with a device. For cell phone providers, for cell phones, there are also rules about charges, extra charges, specifically roaming charges and data overcharge. So, if you are in a situation where you are roaming, so let's say you go abroad and you want to use your cell phone, there can be fees that will be applied for you using your provider in those cases. Once you get in a situation where you're roaming, you're supposed to get a text message or a communication that informs you that you are roaming and what the applicable fees are. So usually you receive a text message on your cell phone when you are roaming, and the fees are capped. So the regulation says that the maximum a provider can charge you is $100, and after $100, the service will be blocked and you won't be able to you won't have an extra charge app applied unless you expressly consent for charges to go higher than $100. So it's capped at $100. Same thing with data charges. So if you have data on your plan and you exceed the allocated data, you can have extra fees, but the fees can be a maximum of $50 unless again you expressly consented to it being able to go higher than $50. So you will once again receive usually a text message. And if you get to the limit, they will inform you that you arrived at the limit and the service will be cut. And the maximum you will have to pay on your bill at the end of the month is $50. This was put in place because there were situations where people went roaming or they used their data, and then the end of the month they had a charge of multiple hundreds of dollars. That was a surprise on their bill. And now we've capped it at this amount unless you expressly want it to go higher. Uh, Complaints against telecom providers. So if you have a disagreement on, for example, the fees you're paying, the bills you're paying, or the services you received, you can file a complaint at the CCTS. They have a form on their website to file a complaint. You can also call them, and what they will do at first is take your complaint and forward it to your telecom provider to try to reach a solution directly with the telecoms provider. Usually, most cases are resolved at this stage. And if it doesn't work at that stage, they can offer conciliation and do an investigation and then present a resolution to you with your internet service provider or your telecoms provider. It's free. Their services are free. So it's a good way if you have a problem with your telecoms provider to try to solve the situation or get an amount of money back when you consider that you paid more on your bill that you were supposed to, and it's easily faster than going to court. So that's a good alternative when it comes to telecoms provider to know about the CCTS and your possibility to file a complaint directly to them to solve the issue you have with your telecoms provider. We still have a bit of time, so we'll go over the options in the case of disagreement with a merchant. So I spoke a bit about mediation, formal notice, small claims court. You now know your rights, but what do you do when you feel they haven't been respected? So there are a number of options you can do, from the least formal to the most formal, let's say. So the first thing is the online notice. That's a way to sometimes show that you were dissatisfied by the services or the goods you received from a merchant. So it's basically leaving a review online. Usually it's on social media um, or let's say Google, or where you can send your review about a merchant. So it can be a good idea, a good way to say you were that dissatisfied. And sometimes some merchants, they are mindful of their reputation, and they will offer to solve the issue, to resolve the issue directly with you after you've posted a review on evaluation sites or social media. One thing to be mindful of, though, if you decide to write a review and post a review about a merchant, is to try to keep it as much as possible to the facts. Avoid some personal attacks, some or giving them an intention by saying they were stealing from you, or fraudsters. So avoid these types of comments when you write a review. Stick to the facts, say what happened, and then the readers will understand that you've had a bad situation. We have seen cases where consumers were sued for defamation for reviews they have posted. That is why we say it's important to be mindful of what you write. It's absolutely possible for you to write a review when you are dissatisfied, but keep it to the facts and avoid any personal attacks, any offensive language, any campaign to say to not go to the merchant, for example, because they stole from you. Those types of comments should not be in reviews, but you can use it to try to get the attention of the merchant, and sometimes even solve the issue directly after you left the review. The other option is complaints. So there are institutions where you can file complaints against a merchant if you have problems with them. We have spoken about the CCTS a couple of seconds ago. So there is a CCTS where you can file a complaint directly with the institution to try to solve the issue with the merchant. There are other options as well for other types of contracts. So if you have a problem with an airline because your flight was canceled or delayed, you can go to the Canadian Transportation Agency to file a complaint against your airline in cases where they lost your luggage, you were denied boarding, your flight was canceled, or it was delayed. Those are situations that can be looked at with the CTA. The Office for Consumer Protection also takes complaints against merchants. So, in general, you can file a complaint against a merchant at the Office for Consumer Protection by contacting them. They also have a fund for clients of travel agencies. So, in Quebec, a travel agency needs a permit from the Office de la Protection du Consommateur. If they have a permit and you go on a trip and there's an issue with the trip, so you don't receive what was supposed to be in the contract, for example, you could have a compensation with the fund for clients of travel agencies through the Office de la Protection du Consommateur. There are other institutions as well. So the Commission d'accès à l'information is basically for situations where you feel your privacy and your personal information weren't respected by a merchant. If you have issues about discrimination, that would be the CDPDJ, so the Commission des droits de la personne et de la jeunesse. And lastly, if you have a disagreement with your bank or your financial institution, there is an ombudsman for banks. So where you can file a complaint to have your issue resolved with your bank. Usually you need to go through the internal process of the bank before, and then you go to the ombudsman. for an issue. If you are a client of Desjardins, of Caisse Populaire, and which is not a bank, that will be at the Autorité des marchés financiers, so the IMF, if you have an issue with them. But the other financial institutions, banks that are federal, under the federal charter, would be at the OBSI if you have a complaint and an issue, disagreement to try to solve. So apart from complaints, another option is also mediation. I have spoken about it earlier. So mediation is a way to try to solve an issue where a consumer negotiates with a merchant with an independent third party present, so a mediator. In Quebec, you have the Office for Consumer Protection that has this platform online that's called PAL Consommation that offers mediation for free. If the merchant you have a disagreement with is part of this program, so you have to check on their website, on the Office for Consumer Protection's website, with the get information about a merchant. I showed you earlier, for example, there was a section called Parle Consommation in litige. Then you see if they're a part of the platform. If they are, you can contact the Office for Consumer Protection. And then you can ask for a mediation. They will send you a code so you can have access to the online platform, and then you will have a way to try to arrive at a solution directly with the merchant. It can be faster than using a legal recourse by going to small claims court, for example, and it's also free. If mediation is unavailable or if it doesn't work, you still have recourses. If you can't file a complaint to a specific institution for a type of merchant that is covered by one of these institutions, such as airlines, telecom providers, for example, and you try to negotiate and it didn't work, the next step for you, if you wanna pursue it further, is to send a letter of formal notice. A letter of formal notice doesn't need you, you don't require to hire a lawyer to send one to a merchant. It's simply a letter where you show what the problem is and what the outcome that you are looking for is to this dispute. So, um, you bought your fridge that broke down after a year, and the merchant says it broke down after a year and 2 weeks, so the manufacturer's warranty is not applicable anymore, and there's nothing I can do about it. So you can write a letter saying, I bought a fridge this at your place, at your place of business. It broke down after 1 year, so the fridge was warm, and I lost the food in my fridge. And you can send a letter of formal notice to the merchant. So by saying what you are looking for as a solution, so you can ask to have it replaced, reimbursed, or repaired. And we usually give a specific amount of time to get a response. Usually it's 7 to 10 days. If it's a fridge and you're about to lose your food, you could put a shorter period, but you send the letter usually by the registered mail. So it has a little fee to pay, like a $15 fee. But it's really important to send it because it's a sign that you've given one last choice, one last chance, sorry, to the merchant to solve the issue. There are templates available if you want them. We have one on our website. If you look for formal notices, there is also a form for formal notice on the Office de la Protection du Consommateur's website that you can use. We have a webinar also on writing a formal notice, but it's in French. If ever it's possible for you to consult it and listen to it. It's on Option Consommateurs YouTube page. If you want to listen to it, then we go into details about what to write in the formal notice, what it is, what to include, for example, and we go over writing the letter. But essentially, it's explaining what the problem was, what the solution you're looking for, and giving a deadline for the merchant to respond to you. If you do that and you haven't had a solution, you haven't had a response for the merchant, or you haven't had the possibility of solving the problem at that time, then as someone mentioned earlier with the questions, the last recourse is usually going to court. In consumer law, usually we go to small claims court for claims that are $15,000 and under. Small claims court is a court where you don't have to be you're not actually represented by lawyers, and you can present your case to the judge to have the try to get a judgment in your favor. So usually go to your courthouse to file on paper if you want to. And uh, so yeah, that's the last option is small claims court. We can discuss it more if you have questions about small claims court. But you can indeed ask for the fees. So the fees that apply when you open the case at the court, you have to pay those, but you can ask for them to be refunded if you win your case. At small claims court, there is mediation available for free as well. And it's a good idea to keep all the documentation you have in case of problem with the merchant, so that you can have all the evidence you need when you file your claim, whether it's online or if ever you go to the court. Usually you can go on the website for the Ministère de la Justice to know what courthouse is the one that serves your address, so your place of residence to know where you need to file. So those are the options for situations where you have problems with a merchant. We have time left for questions if there are any others. I don't know, Medzili, if there were other questions in the chat.
We do have questions regarding roaming charges.
Mhm.
So we're being asked for roaming charges. Is the maximum a daily fee? What if you use the roaming service for 1 month?
Yeah, so the maximum is for a billing period. So it's usually a month. So for 1 month, for the time of your billing, the maximum is $100. Unless you specifically tell your provider that you want them to keep charging you and you want to keep using the service, it will be capped at $100.
Okay, so the next question was uh, basically if you don't agree in advance to the fee of $15 a day and you use roaming overseas for 3 weeks, they cannot charge you more than $100.
Yeah, so again, it's for your billing periods. Usually it's a month. And no, if you haven't agreed in advance to be charged more, or you don't enter into contact with them when you reach the limit that you want to keep using the service and be billed accordingly, no, they need to stop charging you and offering you the service after the $100 mark.
Any other questions? If there's no further questions, we're going to conclude. This brings us to the end of today's conference. Thank you very much, Maître Sarah-Ève Levac. On behalf of the Bar of Montreal and its more than 17,000 members, I would like to thank you for your valuable collaboration. I would also like to once again extend my sincere thanks to Option Consommateur for making this conference possible, as well as the Benning Library. And thank you as well to all of you for your participation. I hope you enjoyed the presentation as much as I did. We look forward to seeing you at our upcoming conferences beginning this fall. For more information, please visit visedroit.com. Have a great day, everyone.